Hi guys, it's Kathy. I hope you're doing well. I hope you got some sleep. I hope you're hydrated. Eat some pineapple, it'll make you feel better. So I have another one that I think is really interesting. I think is really, really interesting. It's only 22 minutes long. Um, we'll see. We'll see what you guys think about it. And then, and then we have an update on a case we did in December that really had us all worried. We really were. But after this hearing, you should feel much better about the children or child. Can't remember. Thriving. Thriving. No, Steve, I just started. I know a minute and 20 seconds seems like a long time, but it's not. Okay, here we go with the first one. It's only 22 minutes long. It's in Uganda. Someone who was sentenced with crimes against humanity, war crimes, I think. It's either both, one or the other. And he's appealing the decision. Am I out of sync? Don't worry, once I get small, you won't even notice. So tomorrow, I get fiber installed in the house. And I don't have to worry about Comcast Xfinity anymore. Here we go.
Please be seated. We will go as well.
Same to you.
Good afternoon, everyone. Would the court officer please call the case?
Good afternoon, Madam President. Situation in the Republic of Uganda in the case of the prosecutor versus Dominic Ongwen, case reference ICC 0204-0115, and for the record, we are in open session.
Thank you. My name is Solome Balungi Bosa. I'm presiding in this appeal arising from the case of the prosecutor versus Dominic Ongwen. My fellow judges in this appeal are Judge Tomoko Akane on my immediate right, Judge Luz del Carmen Ibanez Carranza on my immediate left, Judge Gochalo Kipanize on the extreme right, and Judge Eden Balsureni Damdini on the extreme left.
What did she say?
I note for the record that Mr. Ongwen is attending this hearing remotely. I note the presence of the defense team, the legal representatives of victims, the Office of Public Counsel for the Victims, the Trust Fund for Victims, Victims Participation and Repression Section, and the Office of the Prosecutor. I also note for the record that some of the legal representatives of victims are attending this hearing remotely with the authorization of the appeals chamber. I take it that the attendees are the same as the ones appearing on the list, which the court officer kindly provided to the chamber before the hearing. If the composition of any of the teams has changed, please notify the court officer by email. The appeals chamber is today delivering its judgment in the appeal filed by the defense against the decision of Trial Chamber 9 of 28th February 2024, entitled Reparations Order. I shall refer to that decision as the impugned decision. This is a non-authoritative summary of the appeals chamber's written judgment in the appeal. The written judgment is the authoritative text, and it will be notified after this.
This is the international court. So in this courtroom, if I can get them in English, which this one is, obviously, it's crimes, international crimes. Lots of times they're in French, and I can't, and there's nothing I can do about it. But this one was in English.
This hearing. Background to the appeal proceedings. Ms. Ongwen was convicted on 4th February 2021 of crimes against humanity and war crimes and sentenced to 25 years of imprisonment. On 28th February 2024, the trial chamber issued the impugned decision, which the defense subsequently appealed. The defense raises 11 grounds of appeal. Today's appeal chamber judgment is unanimous. For the reasons that I shall proceed to outline, the impugned decision is confirmed. The appeal. A, ground of appeal number 1, alleged erroneous refusal to disclose the names of victims. Under the first ground of appeal, the defense submits that the trial chamber erred by refusing to order the disclosure of the names of potential beneficiaries of reparations. The appeal chamber notes, when deciding to maintain the reductions applied to the potential beneficiaries' dossiers, the trial chamber referred to the victims' concerns for their safety upon Mr. Ongwen's return after serving the sentence. In their submissions to the trial chamber.
So he says he shouldn't have to pay reparations or go to jail because they didn't give him the names of the victims. And the victims were like, no, you can't have my name. You're going to come after me.
The victims also referred to the threat which, in their view, the Lord's Resistance Army still poses. The trial chamber thus identified the danger that the disclosure of the identity of potential beneficiaries might cause.
Death.
Furthermore, the appeals chamber notes that despite this non-disclosure, the defense was able to make its observations on the victims' dossiers, and the defense has therefore failed to demonstrate that it was unable to make a fair assessment and that it is right to conduct a meaningful review of the victims' dossiers. And its right to conduct a meaningful review of the victim dossiers was unduly affected. The appeals chamber rejects the first ground of appeal. B, ground of appeal number 2, alleged errors in the trial chamber's findings related to domestic proceedings. Under the second ground of appeal, the defense submits that the trial chamber erred in rejecting the defense's request concerning dual claimants who in the view of the defense will benefit both from an award made by the High Court of Uganda and from the award made in the impugned decision. The appeals chamber observes that the decision of the High Court of Uganda addresses harms arising out of an alleged violation by the government of Uganda of the landowner's right to property and to a clean environment, and not from any crimes under the statute. It therefore rejects the defense's contentions regarding the alleged overlap between the plaintiffs in the case before the High Court of Uganda and the victims in the present case. The appeal chamber rejects the second ground of appeal. Ground of appeal 3. Alleged erroneous presumption regarding residents of IDP camps and non-residents present at the time of the attacks. Under the third ground of appeal, the defense submits that the trial chamber erred by presuming that civilian residents of camps for internally displaced persons, as well as non-residents who were present in the camps at the time of the attacks, were victims of the war crime of attack against the civilian population and persecution. The appeals chamber observes that the defense appears to confuse the aforementioned presumption of victimhood with a presumption of harm adopted by the trial chamber with respect to the victims of the same crimes. The trial chamber, however, clearly considered victimhood and harm as two distinct elements, both of which must be cumulatively met in order for a person to be eligible to benefit from reparations. Furthermore, the defense has not identified any error in the trial chamber's adoption of the aforementioned presumptions of victimhood and harm. The appeal chamber rejects the third ground of appeal. D. 4th, 11th, and 12th grounds of appeal. Alleged errors concerning the trial chamber's consideration of the Acholi traditional and cultural factors and mechanisms. Under the 4th, 11th, and 12th grounds of appeal, the defense alleges error in relation to the trial chamber's consideration of the concept of extended family. It also raises issues concerning the complementary role of the Acholi traditional and cultural mechanisms and factors such as Mato Opot and Chen. The appeals chamber considers that the defense has failed to show any errors in relation to the trial chamber's understanding of the concept of extended family in its determination and projections on indirect victims of the attacks.
I wonder what that
Regarding the
means.
principle of
I
complement.
really wonder what that means. So, extended family of the victims, they get some of the money. But in Uganda, I guess the definition of extended family is different than an international definition. So they're saying it wasn't fair. I wonder, geez, I'd like to know what Uganda thinks would have been fair.
Mentality, to the extent
Yes.
that the defense argues
I
that
go.
the traditional and cultural mechanisms should be incorporated into the court's statutory framework, its argument has already been rejected on appeal. Furthermore, the defense has failed to explain how these mechanisms should be incorporated into the reparation system under the court's legal texts and how such incorporation would affect the scope of Mr. Ongwen's liability for reparations. Contrary to the defense's claim, the trial chamber did not equate Chen to mental illness in Western medicine. Rather, the trial chamber found that the victims of the attacks and direct victims of the crimes against child soldiers suffered moral harm, which includes spiritual disturbances, that is Chen, that had long-lasting consequences.
You heard that. Child soldiers. Child soldiers.
The appeal chamber therefore rejects the 4th, 11th, and 12th grounds of appeal. Fifth ground of appeal. E, fifth ground of appeal, alleged error in the trial chamber's decision to award a symbolic cash payment of euro 750 to each victim. Under the fifth ground of
There he is,
appeal,
Michael.
the defense submits that the trial chamber erred by awarding a symbolic cash payment of euro 750 to each victim, as such an award is not provided for in the statute or the rules. The appeals chamber finds that a trial chamber may order modalities of reparations beyond restitution, compensation, and rehabilitation, including those with a symbolic value. The appeals chamber previously determined that collective reparations can include the payment of sums of money to individuals to repair harm suffered. This does not mean that any such payment must be considered as a compensation. The determination of whether a given modality of reparations is appropriate must be decided on a case-by-case basis. It must be grounded in the determination of the harms caused. The defense has failed to demonstrate that the trial chamber erred when it made a symbolic monetary award. The appeals chamber rejects the fifth ground of appeal.
Good job, girl. Keep going.
F, sixth ground of appeal. Alleged error in prioritizing participating direct victims over non-participating direct victims. Under the sixth ground of appeal, the defense submits that the trial chamber erred by prioritizing participating
I don't
direct
know.
victims over non-participating direct victims. The appeals chamber notes that the defense misrepresents the impugned decision by focusing its arguments on the victim's participation status alone. However, this is merely a part of the
Potato farming.
prioritization scheme, which in fact sets out the priority primarily according to the victim's vulnerability and needs. The appeals chamber rejects the sixth ground of appeal. G, seventh ground of
Macro.
appeal, alleged error in failing to require medical documentation. Under the seventh ground of appeal, the defense submits that the trial chamber erred by failing to require two persons in the sample to provide medical documentation to prove their disabilities. The appeals chamber notes that these two victims in their applications make no mention of either of them having received assistance from a medical professional. The defense does not explain why it believes that they received such assistance. Nor does the defense substantiate its assertion that these two victims have medical documentation concerning their injuries. The appeals chamber rejects the seventh ground of appeal. H, eighth ground of appeal. Alleged errors concerning the scope of Mr. Ongwen's liability in relation to his time as the commander of the senior brigade. Under the eighth ground of appeal, the defense submits that the trial chamber erred in its estimation of the number of victims of the thematic crimes by failing to take into account that Mr. Ongwen was appointed as the commander of the senior brigade on 4th March 2004. The appeals chamber finds it inappropriate that the defense attempts to relitigate the same issue that has already been settled in the previous appellate proceedings with respect to the conviction decision. The appeals chamber finds that the defense has failed to demonstrate an error in the trial chamber's dismissal of the defense's submission in this regard. The appeal chamber rejects the eighth ground of appeal. Ninth ground of appeal. Alleged errors concerning the trial chamber's use of the divisor of 4 instead of 5 in relation to the number of LRA brigades, Lord's Resistance Army brigades. Under the ninth ground of appeal, the defense submits that the trial chamber erred by dividing the estimated number of former child soldiers and victims of sexual and gender-based crimes in the Lord's Resistance Army by 4.
So it's almost over, but before it's over, this guy, there were 5 leaders of this guerrilla group in Uganda. And the only reason why he became one of the leaders was like he was abducted on his way to school one day as a child. And he was a child soldier and went up through the ranks. And his crimes are horrible. His crimes are unimaginable. But he was the lowest member of these 5 leaders. And I think they're all the other ones are dead. He's the only one still alive. And I'm not sure what the judgment was, but it wasn't like life in prison, I don't think. I don't know. I think he only got like 20 some years or something like that. I'm not 100% sure, but he has to pay reparation to all these victims and their families. And the hearing today he is appealing the reparations. He's saying he doesn't have to pay all these people.
Instead of 5. The appeals chamber notes that the defense contends again that there were 4 LRA brigades and Control Alta, which also acted as a brigade, without demonstrating any error by the trial chamber. The appeals chamber finds that defense has not shown that the trial chamber's use of the divisor of 4 was unreasonable. The appeals chamber rejects the 9th ground of appeal. J. 13th ground of appeal, alleged erroneous assessment of moral harm. Under the 13th ground of appeal, the defense submits that the trial chamber erred in determining that victims suffered moral harm without requiring psychological evidence or the examination of victims by a psychologist.
Harm like torture.
However,
Torture is the
defense
harm
raises
they
this
had.
issue for the first time on appeal. It did not raise its concerns in the proceedings before the trial chamber. As a result, the trial chamber did not have an opportunity to consider the defense's arguments in this respect.
I don't have
and
any
make
diamonds.
finding thereupon. If the appeals chamber were to examine them, this would exceed the scope of its appellate review. Therefore, the appeals chamber dismisses these arguments of the defense. The defense also avers that it was a double standard for the trial chamber to refuse to recognize Mr. Ongwen's victimhood while addressing similar victimhood with respect to victims of the Lord's Resistance Army.
So like what they did to him
LRA.
when he was a child, they abduct him. He's on his way to school. They abduct him. And then they torture him. And then it's like brainwashing. They make him sit and watch violence until that's all he knows. And then he starts training, shooting, killing, torturing. So that's all he knew from the youngest of young age. It's all they played for him. They tortured him themselves. That doesn't mean, that doesn't mean anything. It doesn't mean he gets a free pass because he was tortured. He can torture other people. But that's how he grew up. That's how he was raised.
However, the trial chamber made findings on Mr. Ongwen's victimhood in order to determine whether he was criminally responsible.
He's criminally
This is
responsible.
materially different
Mike is
from
still
the
on.
present reparation proceedings, where the trial chamber's inquiry was whether victims are eligible to benefit from the awards for reparations. The appeal chamber rejects the 13th ground of appeal. K, 14th ground of appeal. Alleged errors concerning the trial chamber's eligibility assessment of 4 victims in the sample. Under the 14th ground of appeal, the defense submits that the trial chamber erred in its assessment of the dossiers of 4 victims because it did not meet the standard of balance of probabilities. In respect of the first and second victims, the appeals chamber notes that the defense misrepresents the trial chamber's relevant findings and fails to identify any error of the trial chamber therein. Regarding the third and fourth victims, the appeals chamber notes that the defense was able to make its observations on their dossiers, despite the reductions applied to some of the information. Furthermore, the trial chamber had before it the unredacted accounts of all victims in the sample, and on this basis, it was
Oh my God. Could you imagine being on the trial chamber? Oh, geez. They heard, okay, they took a sample of the victims to come up with the decisions they came up with. However, they heard the evidence from all the victims that were still alive. Oh, oh,
was able to determine coherency and credibility of their accounts.
yikes.
The appeal chamber rejects the 14th ground of appeal. 5. Final remarks. I should like to end by thanking my colleagues on the bench, counsels of the defense, the victims groups, the Trust Fund for Victims, the Victim Participation and Representation section, as well as the staff of the chamber who worked on this judgment, all of the staff of the registry, including the transcribers, interpreters, and security personnel who have assisted with today's hearing. There's a lot of work that goes on behind the scenes to ensure that these hearings run smoothly, and the appeals chamber is very grateful to all those involved. This marks the end of these proceedings.
He lost everything. He lost all the
All
appeals.
rise. We agree.
Okay. Next. Back in December, we watched a juvenile, what is it? Lenawee County. We watched this 2 parents trying to get their kids back. And I can't remember if it's 1 child or 2. Just so you know, the child is fine. The child lives with an aunt, I believe, because they do great with their cousins. So I'm guessing they live with most likely one of the mother's siblings, aunt or uncle. But the father was horrible, and he was arguing with the court. He was arguing with everybody, and the mother was really hardly any better. She was slightly better. So it's been a few months. So we're gonna see how they progressed and see what's going to happen with this child. The child back in December was in bad shape. Speech issues, couldn't talk. I can't remember how old they were, but very isolated, very I'm tired. What's the word? They aren't progressed as much as they should be. They were still way, you know what I mean, developmentally. Give me a word, CJ. CJ will type the next word in this chat. Not challenged, retarded, developmentally retarded, not mentally retarded. That's not what I mean. They aren't. No. Delayed is great. Thank you. Like they were like 3 years behind what they should have been. And violent. The child was violent. Would, just bite, kick, hit, scream whenever they didn't get their way, or it was demon child, almost as bad as my children. So the parents had work to do. There was a lot of domestic violence in the house. So the parents had work to do. So we're going to see their progress. And we get to see Mr. Brooks. We get to see Mr. Brooks again. And I guess he thinks this is a counseling session. I don't know. We'll see.
Record for what's been documented is the second regular review for both parents in this file
Daryl,
and the permanency planning hearing. May I have the names of our participants, please?
Good afternoon, Your Honor. Nicole Underwood, lawyer guardian ad litem for the minor child.
Ms. Saja Thomas, counsel for the department. Ms. Dela Garza.
Randy De La Garza, the foster care worker with Fostering Solutions.
Michael Brooks, I'm the attorney for Harold Hollis.
we hate him and love him because we hate him.
Harold?
Yeah, Harold Hollis. Michael McFarland, representing mother, please introduce yourself.
Sorry,
Erica Hollis.
thank you. All right, Ms. Underwood.
Your Honor, I was able to meet with the minor child at her school this last reporting period. She is doing very well there. She was excited and happy to see me. I've become quite familiar with her over the last several months. Her speech is just blossoming. We were in a room where there was several little stuffed animals and things on a desk, and she was going through and identifying all the animals and talking to me about them. She is thriving not only at school, but also in her placement.
The thing that got me the most for this child is eating. When she first got to her aunt's, you'll hear this, like it was obvious that she was starved, like consistently starved.
She's very familiar with the placement. Enjoys being around her cousins and is thriving. She now has glasses, which I think she may have had at the last reporting period as well.
Glasses.
There was one issue where
Yes,
she needed to go either to urgent care or the ER. She had what seemed like an asthmatic episode, but that was treated appropriately, and I believe she hasn't been out for that. I had to ask the court for an ex parte order, which this court granted, allowing the placement to take the child on spring break, as the parents were not willing to agree to that.
Parents said no.
But other than that, her needs are being met in her current placement.
Assholes.
She's in a least restrictive environment, and I believe that staying there continues to be in her best interest.
Thank you. Testimony today, Ms. Thomas.
Love Miss
Thank you, Your Honor.
Thomas.
I'll
Love thorough.
ask Ms. Dela Garza to be sworn in at this time.
I swear witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Don't throw anything at your monitors. He does, doesn't he?
Ms.
Right.
Thomas, whenever you're ready.
Thank you. Ms. Dela Garza, you've prepared a court report for today's hearing. And your cover page indicates that there are the case service plans for the parents, the initial case service plan through Orchard's Family Services, a couple of certificates from the MSU Extension regarding mom's completion of those, a couple of courses, and then a correspondence email from
Maybe. I'm trying to remember. It's possible. This guy, the father is a complete nightmare.
Orchards. Are there any updates or modifications that need to be made to any of those documents that I've listed?
No.
And the case service plans that are included in the court report, those look like they are not signed by the parents. Do you have any updated signed versions at this time?
Yes, I do, and I brought copies with me today.
Okay. And have you been able to circulate those to Mr. McFarland and Mr. Brooks
You and me
Ms.
both. I
Underwood?
want to so bad.
No, not yet.
Okay.
So, just so you know, which you don't care, but I'm going to tell you anyway. There's a little other mod, a game of Minecraft that's not like the regular Minecraft, where in Minecraft you land on this whole world and then you build and you mine and you fight and you have. the whole goal of the original one was to, make a portal to somewhere else and kill this dragon. That was the whole goal. But hi, Fozzie. There's another sort of mod, okay? Another mini game, I should say. I know you don't understand that. A mini game where you land on, like, it's just a few squares big, and that's it. And there's some lava, and there's some water, and there's a tree. And from that, you have to build your own entire world. Or there's quests that you have to do and things like that. But it's called Skyblock. And it's so much fun, and it's so frustrating. But what we saw, if you can imagine, was Skyblock. They built everything from just this tiny little, it's hard. It is hard. It's mini games inside of the game. I have in Skyblock once, if you keep building outwards in Skyblock, it takes forever, but you eventually get to the world. You can build a bridge that goes the whole way to the world, but it takes forever. So you're really just in the middle of nowhere with a tree, lava, and water. And you just live and build from that, and it's great. So that's what we should all do. We should all just start our own little Skyblock and see how far we can get. But instead, we're going to see a child thrive. Go, child, go. That's the mom. Don't throw anything at their screen. Don't.
As it relates to the parents, at the last hearing, the court changed the goal to a dual goal of reunification and adoption. At this time, how would you describe the parents' progress towards reunification?
I would say that they are partially participating in services. Both of them during this report period have changed therapists due to being dropped by their previous therapist that they had.
Yo, it's bad to get a divorce, or break up with your boyfriend or girlfriend. But when your therapist breaks up with you, that is a whole nother level of just the worst breakup ever.
They have not completed the SUD evaluation yet, although it is my understanding that it's scheduled, but there was no release time, so I'm just going off of what parents had stated to me. And they have been participating in the Orchards program since they were referred for a second time.
Okay. In the Orchards report, there's an indication that the parents reported to that worker. I don't feel like they are being listened to in various areas of the case. Were you able to address that with the parents during this review period?
I didn't address that specifically, but we have had family team meetings scheduled with them every other week with myself, the parents, and Miss Moore.
And during those family team meetings, your report indicates that they're used to, I think, track the progress of the case service plan for both the parents and their compliance with that. Are you able to
track the progress? Don't worry, not many crayons were harmed in the making of that progress tracker.
Utilize those family team meetings and achieve those goals with the parents?
We have been able to utilize those meetings. On a couple of the meetings, Mr. Hollis has become argumentative.
Yes, you do.
About things that we've previously talked about. And there was one meeting that they didn't show for, but other than that, yes.
Do you have any concerns about the family continuing to work with Miss Moore?
Mr. Hollis has stated that he refuses to work with her, refuses to go to her office. We've held the meetings over Zoom because of that, but unless Mr. Hollis has asked something directly, does not answer usually.
I didn't hear the last part.
Unless Mr. Hollis has asked something directly, he doesn't usually answer any questions.
And during these meetings, has Ms. Moore indicated what she would expect to see from the parents in order to recommend parenting time be reinstated?
Yes, she has, and I complete the FTM form each time and send it to all parties also, just so that we're all on the same page.
Okay. And what is, I believe this is in your report, but can you just highlight and articulate for the record what exactly is not being done by the parents that Ms. Moore is still recommending parenting time remain suspended?
Everything. Just say everything.
They
You've got
have
it
not
covered.
completed any drug screens. They did complete one today at 2:30 before coming to the courthouse, but they were hoping that after taking the one drug test that they would be able to get a visit today, but I explained to them that we don't get the results right away, and it's something that they need to be continuously working on, not just do one time.
And is drug screening the only thing that they're not doing?
They have not done the SUD evaluation yet. They have, like I said, they have participated with their therapist. Mr. Hollis has attended all of his therapy appointments, but his counselor still chose to drop him in February. And Ms. Hollis was dropped because of so many no-shows that she had.
And is it Ms. Moore's recommendation that the parents demonstrate stable compliance with their case service plan before she's willing to recommend parenting time?
Yes.
To the best of your knowledge, has there been any impact on the child since the parenting time has been suspended?
The impact that I've seen during home visits and have also heard from the caregivers is that she is doing very well. They have her on a routine in the home and she's going to school, as Ms. Underwood mentioned, and she's just thriving in the placement. She's does well with the household members. She's bonded to the caregivers, and a lot of the behaviors that she was showing during parenting times, like the waking up having nightmares, hitting people, trying to kick people, things like that, have all disappeared.
That's amazing. That's amazing.
Is there anything, I know that one of the concerns in the report, the reason this case came under the court's jurisdiction also related to domestic violence. Has there been any progress on that issue?
No, they both continue to state that there was no domestic violence and minimize what has previously been reported in court. So no, they have not participated in any services regarding that.
And have referrals been made?
Yes, I did give Mr. Hollis the information for the DVAP program through John Bailey.
The child is so
And what about for Ms.
lucky.
Hollis?
It's so good.
I know the orchards worker is touching on that subject, and they're supposed to be working on that through their therapy sessions also.
Do you mean in their individual therapy with their respective therapists?
Yes.
Okay. Do you have releases with their individual therapist?
I do, yes.
Okay. And have you been able to provide their therapist with like their psychologicals or any court orders or like the case service plan?
I did send them to Erica's new therapist. I sent them over to Mr. Hollis's therapist, but she is on vacation this week, is what my understanding is.
Okay. And at this time, do you believe that there's been sufficient progress to continue towards the goal of reunification in any form?
I don't know.
The current caregivers for the child, are they willing to provide permanency through adoption?
Yes.
And I know that there had been some issues in the
Miss Thomas, can you be quiet for 1 second? Can we all just still appreciate how awesome the judge's hair is every single time?
beginning of this case with harassing behaviors towards the relative caregivers. Has that continued or has that subsided? Is there any update on that?
I do know that a acquaintance of Mr. Hollis showed up at their home one day. I'm not sure if that has anything to do with the parents or not, but the family is worried about that and they're getting a security system because of that.
And they told the courts. They told her right away. Yo, dad's family's coming, dad's friend or whatever came. So it just makes me feel a little better that they won't cave if mom and dad try to come over. They're not going to say, okay, just, do it quietly. You can come in and see this daughter, I think. No, they're not going to allow it. They're just not. It's so good. Her name is
All
Kathy.
right.
Kathy.
And can you just briefly summarize the risk of harm to the child if the court were to return the child to the parents' care and custody today?
Yes, I believe that she would be at risk for witnessing domestic violence in the home. Also the substance abuse, since they have not completed anything in that area, I'm not sure if they are using substances or if this is a struggle of theirs. Also the mental health concerns continues as they've not been stable in therapy with the same therapist throughout the case, and also just the overall stability for the parents.
And have you noticed any benefit from services? Like, are they engaging better with you?
No.
Oh, yeah.
How are their interactions with you?
I would say that Mr. House continues to be very argumentative. He doesn't let myself talk usually or Miss Moore, especially if there's something that he does not agree with. And more recently, we have noticed that Miss Hollis has also been more argumentative when talking with workers.
Thank you. With that, Your Honor, I have no further questions of Ms. Garza. I would move to admit the court report with the attachments. With the understanding that there are signed case service plans in the courtroom, I believe we would just need someone to hand them to the court.
Are they gonna be different than the ones that are unsigned?
They're not different. The only difference is that they sign them.
Okay. All right, objection, counselors?
No objection, and my client acknowledged that she has signed a case service plan.
No objection.
Thank you. They are received and we'll look for those signed case service plans to replace the ones I have. That's all. Questions, Mr. McFarland?
You testify there's no evidence of refraining from drug use, correct?
Yes.
Well, of course, they've been to therapists, they've been to various other meetings. I don't see a single commentary in your report where anybody's reported or suspected them of using drugs, correct?
That's not something that the therapist touches on with them.
Well, if a therapist thought that they were high, they would put that in a report, correct?
I'm not a therapist, I'm not sure, but I would hope so, yes.
Okay.
I'm a therapist.
Nobody's reported to you that they've been high or under the influence of drugs, correct?
I actually did. This is not a joke, but it's funny. Just to a few of you. I did take 2 years. I did of psychology in high school. I went for child psychology for 2 years. You know what that means, right?
No.
You don't have any police reports in the last reporting period where police have been out to their house or incidents or reports of domestic violence, correct?
Correct.
Nobody has reported to you that they have seen them in a domestic violence situation, correct?
Not in the domestic violence situation, but Ms. Hollis has told me that one of the barriers of her getting to the office to drug screen and things like that is that he will not allow her to use the truck.
That's not domestic violence, right?
It's a controlling situation, yes, I believe.
Maybe she's a bad driver. That could also be another reason, right? Let me rephrase. Have you asked her specifically why she's not being able to use the truck?
She has stated that he will not allow her to.
Did
I
you ask
believe
Mr.
that.
Hollis why he does not want her?
No.
Okay, so you're speculating, right?
Sure.
If the drug test comes back negative that they took today, what are your thoughts then about some type of supervised visit?
So I know that Ms. Moore has the discretion currently, and she has stated that she wants to see them participate in services, not just more than one time, but continuously.
Where should my client be focusing the majority of her efforts on the case service plan, in your opinion?
So this lawyer scared me. I'll tell you why after he does it.
I would say continuing taking medication and doing her medication reviews and continuing or participating in therapy consistently.
My understanding, she's not met with her new therapist, but when she does, do you wish for her to sign a release?
She has met with her and she's already signed a release. I've already spoken to her.
Okay,
Good job, lawyer.
no further questions.
Mr. Brooks.
Here we go.
I've been in this case since the beginning. Very first hearing. I have heard allegations against my client that he may be a drug user. I've seen no evidence of it. None. He took a test today. When will that be available?
We usually don't get them for a couple days, so probably the middle of next week or end of next week.
Are you expecting this court to take, based on no evidence, that he's a potential drug user?
Yes. Look at her.
Can
Look
you
at the
repeat
judge.
that? Sorry.
Wait.
I can't
I'm
hear you.
rewinding
Can you
it.
repeat that?
That he's a potential drug
Look
user.
at the judge. Watch.
Can you repeat that? Sorry.
I can't hear you.
Can you repeat that?
Are you asking this court to take it as evidence that my client is a drug user without having submitted any evidence of any kind that he is?
That was one of the reasons that the child came into care, and he hasn't screened to show that he's sober either.
Wait a minute. Sober alcohol or sober street drugs?
Of anything,
Pardon me?
of anything,
Do you have evidence of any of that?
just from the petition, the removal petition.
Which has yet to be proven he was or is a substance abuser of any kind. Isn't that right?
That's why we asked for him to take do an evaluation.
I'm very aware of that policy. I want to know if you have positive proof. You can lay on that judge's desk and see.
I'm gonna object as the parties have agreed to take drug screens as a part of their case services plan. And part of the report indicates that non-testing shall be considered a positive drug screen.
Yeah, as I recall it, Mr. Brooks, the concern for your client was the prior drunk driving and concern that use of alcohol could result in domestic violence within the relationship. And concern for Ms. Walker was that some of the behavior that she's exhibited, which is indicated to be as a result of mental health, could have also been complicated potentially by substances, including but not limited to alcohol. So that was the reason for the request that they both submit to an evaluation.
All right,
Is that your impression?
Yes,
Good, that's the impression I intended to convey.
yes.
Thank you.
who is the unnamed acquaintance of my client that allegedly went over to the foster family's home?
I don't know the name, but the family stated that they do know that he is an acquaintance of Harold, and they have him on video.
Somebody who's not here today knows, that guy knows this guy.
Yes, because he gave them their address.
That is not evidence. Shh, be quiet. So we have no evidence that my client had any connection at all to do with A, the decision, or B, the action of harassing those foster parents, nor do we know specifically what the harassment was. Do you contest what I just said?
They do have on video what he stated,
Who asked?
the carriers.
You don't have.
I don't.
Mr. Hollis, apparently, according to your testimony, attended
Father.
all of his therapy sessions with the, what is that therapist's name, who you say is dismissed?
Kim Yoder is the one that dropped
Jim
him.
Yoder,
Yes,
and yet she's telling you she has dropped him?
that's correct. I did email with her today to try to get more explanation because Mr. Hollis stated he wasn't aware why he was dropped either.
Was he threatening her? Was he argumentative with her? Was he refusing to attend the meetings? What?
She stated that she felt he needed anger management and was not willing to work towards the goal of getting his child back or visits back. So she tried to refer him to someone more experienced, but he refused.
Like who?
I'm assuming the one that he's working with now.
When's the last time Mrs. Hollis filed a complaint for domestic violence?
I don't know the last time she filed one, but she's spoken with me about how she's wanted to move out because of how he was acting towards her and she doesn't want to work with him and things like that, and then turns around and says that they're back together and working together.
I'm going to object because I don't believe that's in this reporting period. I put up to the last report.
Would you clarify? Was
Yes,
that recently?
That was the last reporting period.
Okay, thank you.
Whose truck is that the family is using for transportation?
Ms. Hollis stated that it's Mr. Hollis's truck.
That last shirt tried to kill me. Thought I was gonna die.
What specific harm would be done to this child if these people were allowed supervised visitation?
Just the parenting skills that we've talked about in previous court hearings. And again, we're not sure if they're abusing substances at this time. They need to continue to work towards or participate in their services.
I have nothing further.
Questions, Ms. Underwood?
Approximately how many drug screens have you offered the Hollises in the last reporting period?
It's been once a week that I've offered.
So several.
Yes,
And until today, how many had they attended or how many had they actually submitted to?
none.
That's the relevancy right there, Donald. She can't take her drug tests because she doesn't have a ride. Can't drive the truck.
Do the Hollises seem to be benefiting from any of the services that they are engaging in?
I don't believe so because it's the same arguments that they're trying to have with workers and service providers if they're not being told what they want to hear.
What are the arguments that they're making that impede their progress?
They're continuing to state that they should be able to tell the child that that the caregivers are not her mom and dad, because they've heard her say mom before referring to the caregiver. They argue that they feel they are doing everything and all of their services and feel like they should be getting a visit instead of focusing on actually participating in their services consistently.
Have the Hollises taken any accountability for why their child is in foster care right now?
No.
Thinking of further questions.
All right, any redirect, Ms. Thomas?
No, Your Honor.
Mr. McFarland, any more questions?
Brief recross, as far as domestic violence, you don't suspect that the parents might engage in domestic violence with each other if they were to have parenting time, do you?
Yes. I mean, hell yes.
During parenting
How can I
time,
say yes more yesy?
Ms. Moore has stated that she feels that Mr. Hollis is very controlling during parenting time visits that have been supervised.
So that could be resolved for my client, for her having individual visits, could.
Boom. That right there. There, he said it. Because this lawyer could possibly win that argument. The mother can have some visits. No, sir. No, sir. Absolutely not, sir. Well, you'll see why I feel so strongly. You met the mother before, but in case you've forgotten, she's going to get on the stand. And what the lawyer just did scared me down to my core.
Well, and part of the reason that her visits were suspended also was because she does not engage well with the child during visits.
My question was domestic violence, wasn't it? Not engagement. I'd ask that be struck, Your Honor, as not directly answering my question about domestic violence.
Response, Ms.
I know how to
Thomas?
swear better in languages than talk.
Your Honor, I mean, I think my main argument is rules of evidence don't apply at these proceedings. They're pretty lax and we allow a lot of testimony to go and a lot of poor-formed questions to be asked. So I think that it's a relevant answer to the issue of continuing to suspend parenting time. And I also think the court's very aware of the concerns that were brought to its attention by Ms. Moore.
You like to weigh in, Ms. Underwood?
Your Honor, the follow-up question that Mr. McFarland said was, could she just have individual visits? So I believe that Ms. De La Garza's answer was based off of this very general question.
I would tend to agree. So I'm going to overrule the request to strike that testimony, Mr. McFarland.
Thank you. As far as supervised visits, if a parent appears under the influence of drugs, it's your policy that they're not to have visits, correct?
Correct.
There'd be no harm with controlled substances at visits if they're not able to have a visit. They appear under the effect of what you might think might be drugs, correct?
That's not the only concern, but yes, correct.
Nothing further.
Mr. Brooks, any other recross?
No.
Ms. Underwood?
No, Your Honor.
Thank you for your testimony. May I return to your seat? If you could locate those signed case services plans, I'd like to get those swapped. Deputy Ames, if you could please, Ms. De La Garza is going to hand over some signed exhibits in exchange for our unsigned.
I think mom is next.
Yep.
Yep.
Thank you.
Sure.
I acknowledge I've received a copy of signed.
So have I.
Gentlemen, Ms. Underwood, any objection?
No objection.
Well, they are received, they are signed. All right. Any other witnesses, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
Wishes to testify today. My client wishes to testify.
Well. Erica Hollis, is that right?
Yeah.
All right, come on up.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Don't forget there's a step here.
All right, mom, mom's up. Hi, mom.
Go ahead whenever you're ready.
Let's address a couple questions. First of all, why is the reason that you agreed to do drug testing today?
Well, because for one, I just decided, let's just do it. Trying to get our kid back, trying to get visit, trying to get something.
What about future drug testing? Are you okay with that?
Yep.
Domestic violence, have there been any domestic incidents between you and Mr. Hollis since we last met here in court?
Nope.
Now, harmony on the marital front, is that what we're hearing?
Yeah, yes.
Have you read your case service plan?
Yeah.
Okay. Do you have any questions regarding what you're supposed to do?
No. I know what I'm supposed to do, and there's just one slight issue on the whole service plan thing.
What is that?
And then I didn't feel so scared about what the lawyer asked for.
I didn't get dropped for no shows from council.
Okay.
I did call both days, and they said my therapist was out sick. And then both days she was out sick, and then I got an email from my therapist stating that she was dropping me because I did no call, no shows. Now, to me, that's calling. I called both days.
You called both days and your testimony is that your therapist was sick?
That's what they told me on the phone, that she was sick both days.
But you have a replacement therapist, is that my understanding?
Yeah, I got a different therapist at a different place because I was done with that.
Who is that therapist?
Her name is Mariana at River Oaks.
And you've not met with her before, if I recall.
I met with her twice so far. Well, today was the third time.
Did your personality seem to click pretty good?
Yeah.
You wanted to express your feelings today, your thoughts about parenting time, correct?
Yes.
What are your feelings?
My feelings is, we've been going to counseling. I've been taking my meds every day. Yeah, we did a drug test today. I see us going forward, not backwards.
You get your prescription for your meds.
I get it through ACPC still.
Okay. You've been regularly meeting with a therapist through ACPC?
Yeah.
Who's that?
Robert Shaw.
You think the medicines are helping you out?
Yes, but I am in the process of changing doctors. Because I want to
Yes,
get
you
out
are.
of ACPC altogether because they dropped me as a patient for no reason. So I just don't even want to.
So your therapist dropped you
So
for
I'm
no
getting a
reason,
different
and your
doctor.
doctor dropped
So
you
that
for
will be
no
changed.
reason.
You know that the goal request from the agency is to change this to adoption, which means a termination trial of your parental rights. You understand
Insanity.
what they're asking for.
Yes, I do, and that's not gonna happen. Because I don't see how they can change it to that when we are trying. I see us trying.
Okay.
I mean, I think we've done more now than we did the last report.
Is there any way that we can
Calm
perhaps assist you to be
down.
more compliant in their eyes?
Spicy today.
I mean, I'm trying the best I can, you know, I mean, I get dropped for no reason, so then I gotta start over, I feel like, you know?
Well, the workers made an issue
I
that you
call
don't have
bullshit,
access to
too.
pick up trucks. I don't know
Mounds of
anything
it.
about that. Is there anything you want to share with us on that?
Well, the last truck got wrecked, so no, we don't have Harold's vehicle anymore. We are
You
using
are?
his friend's vehicle at the time. We're getting around to.
Do they not trust your driving skills?
Well, he's not my friend, but that's Harold gets permission
See
to
high
drive
on
the truck.
life. Life.
So you don't have permission to drive the truck. Is that what we're hearing?
Yeah,
Okay. Any other way that we can assist? Do you need to?
I'm working on
Hang
that vehicle, I'm
Do you-
working on
Do
it.
you need Lenawee transportation vouchers so you can go to things?
See, that's the thing, I know Dollar Ride does not come out to my house because I've already asked.
Well, Delaware may not, but how about Lenawee County Transportation? Have you checked with them?
I just didn't call anybody else because I figured I live out in the country, so I'm figuring the Dollar Ride don't come out there, I'm sure nobody else is gonna come out there. Unless I got buku money, you know, to spend on a taxi cab, then I might be able, I mean, it's $33 to get from, with Jeff Rides, you know, $33 just to get from Sutton Road to Adrian. I mean, that's a lot of money, just one way.
Would you attempt to call Lenawee Transportation, then get vouchers if they would indeed come out?
Well, if I could,
If the ride to take a test would cost $1 million, and that's what I needed to go see my child, bitch, I would be a millionaire in 2 days.
but,
Okay, you have a telephone.
yeah,
Okay. Any other way that you think we can help you?
no, that's about it.
Anything else you don't understand?
No,
We're gonna leave this for other attorneys to ask you questions if they want to then, okay? Okay,
yeah.
Questions, Ms. Devitt?
No, Your Honor.
Mr. Brooks?
I have one, but I don't think I'm gonna ask. Thank you.
Why did you wait until today to take your first drug test?
Like I said, I just wanna try to get my kid back. I'm trying to work towards it. I'm trying to do it, but then I feel like I'm getting told that we're not doing it, but we are. We're trying to go forward here.
But why have you not taken any before today, is my question.
Because honestly, I don't trust any of them. I mean, they're already lying about me getting dropped as a patient from my counselor. That's not why I got dropped. That's not what happened. At least, you know, what they could have done was, hey, we got told Erica did no call, no shows. But really, what happened is what Erica called, right? But it doesn't say that in there, does it? And that is the truth.
No further questions.
All right, any redirect, Mr. McFarland?
I do not.
Thank you for your testimony. You may return to your seat.
No further witnesses.
Mr.
Harold
Brooks?
Hollis. You don't wanna go up? You sure?
Raise your right hand, please, sir. You swear or affirm to, can you look at me, please, sir? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yeah.
Harold, we're gonna talk a little bit here, okay? You know I've been doing this longer than you've been alive.
All of
don't
it.
you? Yeah, yeah. I am aware that you have anger issues, and you have awareness that you have anger issues, right?
Yes.
So let me ask you a simple question. In your whole life, have there ever been things that didn't tick you off,
Yeah.
but not lately?
No.
And so you continue to oppose and to argue and to fight, right?
With who?
The department.
I'm trying not to do, I try not to say anything unless they ask me, and that's what I've been doing. If they ask me something, I say something.
Don't you recognize that that in itself is a form of opposition and arguing?
No, no.
Well, it is. You may not be aware of this, so I want you to hear it plain blankety blank English. All this department has to prove to the court at this point is that you will not cooperate with them and thus do not benefit from the services they
Oh,
seek
she's
to
swaying
provide you.
from side to side.
Give me the best damn little parent in the world. But if they say, he just won't go ahead and work with us, which you won't, You realize that's all they need to terminate your parental rights. That's not this judge's decision. It's not mine. It's not the prosecutor's. It's the law.
It's my decision.
I've never told you this before, but I'm telling you now. Keep doing what you're doing and you're gonna lose your child.
What am I doing? I mean, I do what, I'm going to therapy, I'm doing.
Listen to me. You're going to therapy and you're telling them they're full of BS.
No, that's not, I've never told that counselor anything, I've talked to, no, that's not the truth.
So you're being fully cooperative and open with this counselor.
Yeah, with the other one too, and all of a sudden after they talked to her, or whoever they talked to somebody, then the next time I came, she said, well, I can't help you no more. After they talked to them people from here, yeah. Whoever she talked to,
Harold, can you be more
I don't
cooperative?
think that's right, Micah.
I thought I was being cooperative.
You're not. Can you be more cooperative?
I think I'm more cooperative.
Yep,
Quit taking them on.
I'm not taking anybody on.
can't look away.
I ain't taking not a soul on.
What do you call not taking a drug test?
Because if my word ain't good enough, I don't trust her or them, first of all. I don't trust even taking it today with them. I wanted to do it here at the courthouse.
There have been thousands of people have gone through this court system, with me present, who have taken those drug tests. I want you to take those drug tests. Will you do it?
I just did one today.
Yeah, and you missed how many before?
Actually, they never asked me. They left it on their phone about me. They never asked me to do it. But anyway, yeah, problem. I'll do it.
We were all there. You're right. You're right. You are so right, sir. Nobody asked you. But we were all present when she told you. We were all there. We all saw it.
Probably.
I'd like to
about the
hire
things
somebody
that-
of my own to do it.
Sir, do you, that's not gonna be the same.
Okay.
Do you understand you're on the edge of the cliff? One more step in the direction you're going in, and your child's gonna have a different last name. Are you aware of that?
Yeah,
And your wife can say, well, that's not gonna happen. Nobody's gonna ask your opinion or hers. Nobody.
they already got their mind made up anyway, so.
So change it.
I already got their minds
You know
made
what? I
up.
don't know what you want me to
I
do.
change people's minds for
Yeah,
a living.
Kiss their ass, I guess, right? Okay, I'll do
Yep.
whatever you say.
Kiss their ass. That's good.
You want your daughter back.
Yeah, I want her back.
What does it cost you to cooperate with them instead of being objective or,
I ain't been objective to them people.
yes, you
I know I haven't, but either way, if you say so, I'll do whatever you say.
you want your daughter back?
Yeah, I want her back.
Do what I tell you. Do what I tell you. Is there anything else you want to say?
I didn't want to say that. I didn't want to say, no, I'm good.
All right,
Any other questions, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No, thank you.
Ms. Underwood? No, Your Honor. Thank you for your
All right,
testimony,
guys.
Mr. Hollis.
He
You
was
may
so
return to your
much
seat.
better last hearing, but he was okay this one.
Anyone else who wants to hear from?
no,
Ms. Underwood? No, Your Honor. Comments in closing, beginning with Ms. Thomas?
Thank you, Your Honor. I was reviewing my notes from our January hearing, and it really seems that there hasn't been progress in the last 2 months.
B, once B.
And for
He only wants B, so the courts better not give him A because his lawyers are fighting for it. He's not fighting for it. The mom's not fighting for it. The mom and dad are reluctantly doing the bare minimum and less than that. Reluctantly, because they have to. They are doing absolutely nothing to get their child back. And she sees that. So here we go. Here we go. Miss Thomas is going to talk for a bit, make us all feel better.
for those reasons, Your Honor, I believe the court is just very aware of the issues and concerns that brought the child into care His child was removed back in June, and we still haven't been able to progress towards, well, at this point, to look at reinstating parenting time, let alone progressing towards expanding parenting time and unsupervised parenting time, and knowing that the child would be safe in their care. So for those reasons, Your Honor, we are asking the court to consider the singular goal of adoption, and expecting and anticipating a termination petition from the agency, and set it for a 90-day review. Of course, efforts will continue to be made towards reunification, as always, and but I really think the focus should shift towards what this kiddo needs. She's clearly thriving with the stability that's being offered in her placement family, in the routine, being around her foster siblings, and having a normal family life. It's really unfortunate that we haven't seen a change in the, I guess, taking accountability for why this child's in care in 9 months. That hasn't happened. And still really deflecting and
Don't remember.
being
Younger. Not a teenager, I don't think.
distant and hostile towards our caseworkers and providers. And it just seems like it's everyone else's fault other than the parents. So, Your Honor, for those reasons, we are asking the court to change the goal, to order the termination petition to be filed, and to have a 90-day review. Thank you.
I love her.
Comments, Mr. McFarland?
Oh, Your Honor, my client not being able to borrow a friend's truck, I don't really think rises to domestic violence, domestic confrontation, anything of that nature, Your Honor. No police reports, no arrest. Seems as though that's more speculation than anything else.
Mr. Lawyer, do you think maybe you could take the time that you have right there to tell the judge what mom has done to try to get her daughter back, instead of defending what everybody's saying? Tell the lawyer what your mom has done. Let's try that.
I probably had good speculation at that. As far as drugs, well, visits would not have occurred if they were under the influence of drugs. If they're supervised visits, they could easily be cut off if they were suspected under the influence of drugs. Client is signed releases, or if not, she will, my understanding, with this new therapist. She wants to move forward. She has been confrontational in the court before, but I can't remember the last couple of hearings ever being that way. I think she's acquiesced to, at least on the drug issue. She's given a sample. She'll continue to do that down the road. My client would like to see, most importantly, for the court to consider keeping the goal for another review period, or a dual goal, Your Honor, and not converting it to a adoption, which is effectively a termination of parental rights, regardless of how we call it. That's what it is.
Okay, but let's put forth any reason why. Why should they do that? What did she do? Name anything. You heard her on the stand.
Well, let's see when that happens. So, and she does not wish for that to happen. Thank you.
Comments, Mr. Brooks?
I think it was the department's attorney who said this case is 9 months old. In the general scheme of things, it's not very long. I
To
don't
a
think the
child,
court
it
will argue
is.
with me for 1 second.
Yes. You know how many milestones a child hits in 9 months of any year? Pick a year. You know what all they're going through, everything they deal with and go through and learn and grow, and milestones. And they missed them all. So, oh yeah, that's not a long time. You know, if it was like 6 years, then we would be talking. It's 9 months? Nah.
And I say that Harold's not easy to represent. Harold now has been told on the record by his own lawyer, he is 1 step away from having his child taken away from him forever. And he is. You know it. I know it. He's been told that. I want you to give him more time than 9 months to change the way he deals with confrontation, which is to dig his heels in and fight against all logic.
Yeah, that's what he said he was going to do when he was on stand, right? He said he was going to dig his heels in and he was going to try really hard. And, you know, he knew that he has anger problems and he needs to fix them. Like is that what he said on the stand?
Because there's no logic in arguing this point when the cost is he's gonna lose his child. There's none.
Already lost. Already
Take the
lost.
drug tests, listen to what the therapists have to say, talk to them, not just sit there and don't clam up. That's the hurdle we have to get past, not drugs, not domestic violence, none of that stuff. Harold's refusal to listen to somebody and follow instructions he doesn't want to follow. He can continue to do that, that's what he wants to do. Nobody can stop him. But he can't kid himself anymore. And if that's what he wants to do, he might as well quit this court case now and put himself out of his misery. 9 months is too quick. Thank you.
Ms. Underwood?
I love to hate him
I don't think
so
anybody
much. I love it.
Up here likes to sit here and recommend a goal change of adoption when the department's trying to.
I
make
do.
efforts to reunify a child with their family.
No,
However,
I don't want that.
this child deserves stability, permanency, and consistency. While we wait for the Hollises to get over this hurdle that Mr. Brooks indicates there is, we have a child who has spent nearly 2 years of her life out of their care. And in that time, she has been able to get a vision exam and get glasses, go to school with her peers, be in a loving and functioning household free from domestic violence. There's been nothing but blaming everyone else for their issues and their shortcomings. The parents have made probably the least amount of progress that I've seen on a case in 9 months.
Yo, we have seen a lot of cases in front of this judge, and we have never heard her say that ever. And I believe she's right.
And that's not due to the lack of attempts and reasonable efforts, actually active efforts, in my opinion, of the department and the workers that have been put in place to try very hard to help this family. The bottom line is the parents have been given the opportunity to take accountability and to make progress for parenting time and reunification over the last 2 months. And they've really done very little. Showing up for one drug screen on the day of a court hearing is not enough to consider any progress at all, in my opinion. I would ask that the court adopt the goal change, or change the goal to adoption at this time. I believe it's in the child's best interest. And I would agree that there's been little to no progress that would afford the parents any parenting time at this time.
Thank you. The court finds all interested parties were given notice for purposes of today's review and permanency planning hearing.
There's mom
The
shocked.
goal was changed to a dual goal of adoption and reunification at the last review hearing in December. Today, we heard about the parents' attempts to engage with services. Mom has taken some extension education through MSU. Father, Mr. Hollis, has tried to begin engaging in counseling. I think that,
Not you, my God.
while Mr. Hollis stayed for the hearing so far today, that's also progress as far as I'm concerned. And I have to say, I think it did justice to his client that Mr. Brooks really took the time to speak very frankly.
Yeah, but he did it. He did it on the stand. He didn't do it 3 months ago. Like it was all showmanship. That's all it was, is showmanship. I don't know. I don't think it's sad. I just don't. I think it's great. This child is flourishing right now. So I just think this is the best update I've ever played.
With Mr. Hollis on the stand, and that Mr. Hollis did his best to try to understand what he was being told. There's no question that any progress whatsoever in this case would take a very significant amount of time, and the modicum of effort that we've seen this report period is only due in part to the overwhelming, frankly, and very gracious efforts of Ms.
Pressure.
Della Garza, Ms.
Pressure.
Renee Moore, and the other service providers that are tasked with trying to help these parents get out of their own way, to be perfectly frank. So there's no question that we have reasonable efforts, and I would agree even with Ms. Underwood on this point, that we have very active efforts. We have Ms. Moore, Ms. Della Garza meeting regularly, trying to engage with these parents, trying to get them to understand.
Okay. It's sad if you, okay, we grow up and we are told that you are supposed to get this type of love from this type of person and this type of support from this type of person. Like, your parents are supposed to, support you and be there for you and blah, 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 blah. And, your spouse is supposed to love you unconditionally, and your children are supposed to, if you just erase all of that, if you need unconditional love, you can get that from anything, anybody. It doesn't have to be from a parent. If you need support, you can get that from anyone, anywhere. It doesn't have to be from your spouse. If you need, companionship, it doesn't, or whatever, I don't know the right word. You don't have to get that from your kids. You can actually get that from anyone. It's like we are shoved into these, this is how it's supposed to be. Parents are supposed to be like this, and sisters are supposed to be like this, and that's just not how life works. Parents aren't like that. Sisters aren't like that. Spouses definitely aren't like that. This child is getting exactly what this child needs. Not from the parents. Fine. That's perfectly fine. This child it sucks that this child had to deal with these two people for the first small part of her life. But she can get what she needs and thrive from another person. She doesn't have to fit into that mold where, you're supposed to, stick with it, work with your parents. They're your parents. You're not going to get any other parents, or it's your daughter. You're supposed to blah, blah, blah with your daughter. No. You have your needs, whatever they are. Everybody has different needs, and you can get them from anywhere. You don't have to get shoved into a box where you can only get this need filled by this person. What? World's full of people.
What the challenges are in returning their child to their care. There's no question that both of these parents care very much about this child. But the lack of understanding as far as what the challenges are that remain in the way of reunification is very, very much apparent, as reflected in the court report and the testimony of Ms. Della Garza, and in the parents' testimony in and of itself. Ms. Underwood is not wrong. When we heard both parents continue to.
So what happens then with someone who has shitty parents, shitty husband or wife, shitty kids? What happens to them? They can't get any of their needs met because they have to get it in the way that is. That's not true. I don't think that's true. I don't have conditions. Even if they're wrong, even if they're dead wrong, I love them. But no, I mean, you got to do what you do in this world.
Deflect responsibility for some of the challenges that resulted in their child being removed from their care. And the challenges that she faces. She had developmental delays. She needed glasses. She needed analysis for special needs. She now has an IEP for speech and language. She's begun preschool and is making strides in some of those areas that she was previously prohibited from making strides in because her parents, frankly, had her in a household that did have abuse and neglect dynamics associated with it. Her behaviors demonstrated that at the time of her removal. She demonstrated behaviors consistent with food insecurity, hoarding food and stuffing herself during meals. She
That's so
demonstrated
sad.
fear of men and conflict, some traumatized behaviors. She has been removed from the care of her parents since June 22nd of 2024 and is making strides in those areas. Ms. Walker did have a brief hospitalization at the end of December and was poised to re-engage in psychiatric care. I'm going to ask Ms. De La Garza in the next report period to really do her best to secure the analysis that was performed both during that hospitalization as well as through ACPC care. And that's going to depend a lot on Ms. Walker cooperating to get those records around. At this point, I still don't have an official diagnosis for Ms. Walker, what her goals are in therapy, what progress she's made. And that's just as much, if not more, on you, Ms. Walker, as it is on Ms. De La Garza, because Ms. De La Garza is here to report on the progress. And it's not on Ms. De La Garza to go to your house, to pick you up, to get you to sign these. No, all of these things are set up for you to demonstrate that you are able to become a healthy person so that you can become a healthy parent. It's not on Ms. De La Garza to make you into a healthy parent. It's on the two of you to show us that you can do it, to avoid things that were in place when your child was removed from your care. That's it. That's the long and the short of it. Mr. Brooks is right. This, and Ms. Underwood is right. This is a case where we've had very little progress in the 9 months, almost 9 months that your child has been removed from your care. The next 3 months will be imperative for you to show us that you're serious about trying to understand what the barriers are and making progress. I'm going to leave the goal as a dual goal of adoption or reunification. But I can promise you this.
It's
At the
okay.
next hearing,
It's okay,
if
guys.
there's no progress made, it's going to be adoption, and there's going to be an order for the department to file a termination petition within 28 days of that review year. So that's the bottom line. And
Okay.
I wish you the best of luck in overcoming some.
It's over. So, okay, she left dual goals: adoption, unification. There is no way, there is no way that mom and dad are gonna magically see the light right now. And I really think that we're okay. I think that we're gonna go with adoption in a couple months. Yep, he looks devastated, doesn't he? He's crying. He's crying. He wants that kid back so bad. He almost is forgetting the name because it's been so long. It is, because you don't know. You got this, that your baby that you take care of every day. And the courts can just give them back to mom and dad at any second. That is a terrifying, scary place to be. And foster parents, man, they're freaking angels to deal with it. All right. Glue. All right, guys, we did it. We did it. We got a stream together. We did it. I didn't think I was going to be able to do it, and we did it. Whew. All right, I'm going to go to OJ now. I think I have it set up. I don't remember. I think it's set up that everybody will be bumped over. If not, I will see you again soon. I do not stream tomorrow. I have to go to work shortly. So I don't have time to get content today. There won't be any stream tomorrow. It's Wednesday. But I'll see you on Thursday. I hope you guys have a great day. Thank you, everyone. Yeah.
Got these life echoes, digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the just right.